Yes, yeah, thanks.
If it may please the court, my lord, I do confirm my appearance on behalf of accused number 2. And further, my lord, on Friday, Advocate Munisi requested me to stand in on his behalf in respect of Mr. Ngube and Mr. Sibia. I've spoken to both the respective parties and they are amenable, my lord, as the parties.
That's it. Okay. Yes, Mr. Nimano.
This is the court, my lord. I confirm my appearance on behalf of accused number 4. Thank you.
Okay.
Yes, my lord, I confirm my appearance on behalf of number 5.
All right. Yeah, there's one thing I must attend to. All of us, I suppose, we read newspapers. This is proper that I should address this issue. But initially I want to say I have been 26 years on the bench as an acting judge and as a judge. I have never, ever, ever behaved the way I did on Friday. And I've been 30 years as an attorney. Before I became a judge, 30 years I was an attorney. I spoke to the JP, and the JP spoke to me together with the DJP. And the JP rightfully excoriated me for my conduct, that it is not befitting of a judge of my experience and stature, that I should have behaved like I did. And I agree. My conduct was questionable and incorrect. And my wife also, who I thought, young Saba is afraid of me, told me that I should apologize to the whole of South Africa because I am worse than the attorneys who apparently steal the monies of clients in the RAF matter. She was reading a paper the other day about the fact that attorneys apparently, and they are colorless, stole about 1.5 billion of RAF funds which belong to clients. And I wish now to tender my sincerest apologies. It's contra my nature to do that. I have a son, he just died recently, who's an advocate. He's older than you, Ms. Mshololo. He was born in 1968. He died because of lymphatic cancer. I think he would have also have been disappointed at my conduct. That's why I say I heartily and unreservedly, with no qualification, apologize to my colleagues here, to the accused. They say I mustn't call you the accused. They are correct. The gentleman in front of me. And I've also been accused of being a racist. I want to just talk one or two things about me as a person without being a lawyer. I grew up in the house of Moses Kotane. Nelson Mandela used to come at home. Walter Sisulu, even Robert Sobukwe, before he broke away from the ANC. My father was involved as a member of the ANC and the Communist Party. He would be mortified to hear that I am a racist. And another thing which you may not know, my great-grandmother was a German. She was born in Bochum. Apparently he met some German priest, meaning my grandmother was a German. And I recall that She used to cut her hair, crop it short so that people mustn't realize that she's got white blood. So I know everything about racism. I grew up also under the tutelage of the late Bishop Tutu. I was talking to his son, Trevor, yesterday at the seminary. So if you want to know me, whether I'm a racist or not, you can ask, for instance, Archbishop Thabo Makgoba, Father Mkhatshwa, Professor Lesiba Tefu, Professor Seth Cooper, Professor Bani Pichana. I used to be a member of SASO. We founded SASO, 1968. I wasn't a leading light, but at Fort Hare, I was the secretary of the branch there. I can confirm that with Judge Selby Bakwa, who's here. And subsequently, I became a member of the Black People's Convention after the ANC was banned. And subsequently, I became a member of AZAPO, and I was the Secretary for Legal Affairs and Sport when Mrs. Kware was the president of AZAPO. I cut my teeth in politics together with Cyril Ramaphosa. He was my junior, actually, in politics. And I mean, I was tutored by people like Thabo Mbeki. He'd be shocked to hear that I'm a racist. So if people say I'm a racist, maybe I'm not aware of that. But if I trampled on anybody's toes because of my racism, despite being an adherent to the Freedom Charter, 1955, I was there in Kliptown with my father. I wish to apologize for being a racist. I'll try and mend my ways, but I can tell you, it's not a conscious thing about me to be a racist. So I apologize. And the gentleman in front of me, if you believe that I, as a judge, I'm so useless, dumb, paluka, moho, etc., and you think you can't get a fair trial from me, please tell me. I'll recuse myself. I don't want to impose myself on people who doubt my integrity, honor, and dignity. And I mean it. If you think this judge, the way he's a racist, the way he doesn't care for the Constitution, he's not fit to be our judge, please tell me, and I'll recuse myself. Yeah, so that is the apology. My wife actually said to me, I must apologize even to the people of South Africa. And then I asked him jokingly, even the undocumented foreigners, he says, everybody. So I wish to apologize even to the politicians, because I'm told even politicians are worried about me. They want to summon me to Parliament. Don't know for what. And most graciously, I want to apologize to the Chief Justice Maya, to Chief Justice Zondo, to Chief Justice Mogoeng, and to all these colleagues. In particular, for instance, Dikgang Moseneke, Willie Seriti, because those are the contemporaries I started with. And I was also phoned by persons I've tutored as attorneys and advocates. Some of them are on the bench. some of them are at the Constitutional Court. They were also shocked that I'm a racist. Okay, so I hope you accept my apology. And I also want to apologize to all the judges, all the magistrates, all the prosecutors, all the students who are studying law, even those who are not studying law, all the religious leaders, and anybody in South Africa who felt slighted and felt insulted, as the newspapers are saying, by my conduct. Okay, yes, Mr.
As the court pleases, my lord.
Oh, do we have a witness today?
Just interpret the apology.
Oh, okay. Oh, we want to interpret that.
Manje ke inkosi enkantolo ke bafowethu ithanda ukuthi iqoliseke kunina nonke ke nikhona la enkantolo futhi nakumphakathi wonke kwala eNingizimu Afrika futhi nakumajaji wonke ke futhi nakubosopolitiki abakhona ke eParliament ngendlela kade iphethe ngayo kwesontweni endlule futhi uyasho ukuthi nakukhulumile futhi nenkosi nejaji elikhulu la enkantolo futhi nenduna encane ke judge ke lapho ke ngesikhathi bakhuluma benomhlangano wabo fumelana nendlela kade ephethe ngayo ke futhi athanda ukuthi aqolise kunina ke nonkana banomzana futhi asho ukuthi ukuthi anibizeke ukuthi abasolwa ke bengamele ukuthi anibize ukuthi ngabasolwa ukuthi ngabasolwa kwamele ukuthi anibizeke lapho ngezibongo zenu ke noma izibongo zamagama enu ke lapho ke futhi eqolisa kwithimba labashushisi nakwithimba labameli benu futhi nakubosopolitiki bonkana mayelana nendlela kade ephethe ngayo kwesontweni endlule manje athi uqolisa ngokujulile okuphuma ngaphakathi inhlizweni yakhe ke phathi uma ngabe ke ninake nithi yena ke akulona ijaji likhethekile ama ijaji liphethe kahle ke liqala lini noma mhlawumbe icaleni akahlelele phansi ngendlela ekhethekile noma nangendlela enifisa ukuthi bahlalele ngayo ke nimtshele bese nake uzozikhipha ke kuliqala lihle.
Ms. Msholo, I don't want to think I'm picking on you. You don't have to reply. Maybe I come from the old school. You know you were not here for 2 weeks, eh? You know, 2 weeks.
Yes, my lord.
Fine. I thought you would come and see me in my chambers for the indulgence I gave you, but I saw you come in on Friday and you just sat. And because this judge is old-fashioned, I just got baffled. That's all I'm saying. Okay. Yes, Mr. Malui.
As the court please, my lord, we've just handed up heads of argument, my lord, on the application for the recalling of Sergeant Mabasa and Warrant Officer Ndlovu as the downloaders of the devices of accused number 2 and 3 regarding the additional photos that were found on those devices. The court will recall that on Friday, the state wanted to re-examine Brigadier Gininda on these additional photos of accused number 1, 2, and 3. We did not mention accused number 1 on Friday. There are 2 additional photos of his that we intend to use. We mentioned the 16 additional photos of accused number 3, and we mentioned 3 photos of accused number 2. We mentioned 3 photos of accused number 3. This is actually one photo that is shown in 3 different positions. So it's 3 different versions of the same photo. So in essence, it's just one photo. And when we wanted to re-examine Brigadier Gininda on these additional photos, the defense objected to the introduction of the evidence on the basis that it's new evidence and that was not canvassed during cross-examination by defense counsel. The court then ruled that the state must bring a substantive application for the recalling of these downloaders of those additional photos, being Sergeant M. Mabasa and Warrant Officer L.T. Ndlovu, respectively. My Lord, we've already presented a full-on argument on Friday. Today we've prepared a very concise argument which sort of dovetails with the argument that we presented on Friday. So we're not going to rehash some of the points that we argued on Friday. If on that point, then I can refer the court to page 1 of our heads, paragraph 1.1, that we have signaled our intention to hand in 3 additional photos of accused number 3. As I've just explained, that is actually just one photo that is shown in 3 different positions. And this photo was found on the cell phone download of accused number 3. And we're on page 2, and 16 additional photos of accused number 2, which were found on the SD card or the memory card on his cell phone. And these photos also include 2 photos of accused number 1. We mentioned that these additional photos do not form part of any of the exhibits that are before court, but are contained in the totality of the photos that were downloaded on these gadgets mentioned above by the downloaders, namely Sergeant M. Mabasa and Warrant Officer L.T. Ndlovu, respectively. Paragraph 1.2. The state is therefore bringing an application for the recalling of Sergeant Mabasa, the downloader of the cell phone of accused number 3, as per Exhibit S. The court will recall that the evidence that the investigating officer requested at the time that only certain photos found on the downloads of accused number 3 should be included in Exhibit S, being the affidavit of Sergeant Mabasa. Those photos are also included in the affidavit of Lieutenant Colonel Stein, and he has also testified thereon, and they were included in the affidavit of Lieutenant Colonel Stein at the request of the investigating officer, Brigadier Gininda, in order to identify the clothing and the dreadlocks of accused number 3. And this, my lord, we see on the record of the proceedings of the 1st of August 2023, page 8, lines 10 to 11. We mentioned, my lord, that the total number of photos downloaded on the phone of accused number 3 is quite substantial. If my memory serves me well, I think they're in excess of 700 photos. The evidence in chief and cross-examination of Sergeant Mabasa have already been concluded on 1 August 2023. He was subsequently recalled on 24 May 2024. But his evidence has already been dealt with. The CD containing all the photos that were found on the download of accused number 3, and not only those contained in Exhibit S, the affidavit of Sergeant Mabasa, and Exhibit O, that's the affidavit of Lieutenant Colonel Stein, were handed to the defense some time ago. We don't want to commit to a specific year, but it's quite some time ago, my lord. The state seeks to hand in a photo of accused number 3 in the context of 3 versions of the same photo emanating from the extra photos contained in the download, which do not form part of either Exhibit S or currently. Paragraph 1.3. The state also seeks to recall Warrant Officer LT Ndlovu, the downloader of the SD or the memory card found in the cell phone of accused number 2, which was a gold Samsung cell phone. Now, according to his evidence, there's now the evidence of Warrant Officer Ndlovu. The cell phone had 2 SIM cards, which, along with the SD card, were successfully extracted using the XRY technique, but the cell phone itself could not be successfully extracted as it had a pattern, as it was mentioned on Friday. And this we see on the record on the 16th of April 2024, page 18, line 7 and further. He testified that the results were burned on the CD and sealed in a forensic bag. And we mentioned that Warrant Officer LT Ndlovu has already testified and has been cross-examined. If I can then ask the court to turn over the page to page 3, paragraph 1.8. We deal with the law as far as the recalling of a witness is concerned. And we mentioned, my lord, that this application is based on the rule of practice that dictates that in an adversary system such as ours, that there is a search for the truth in order to ensure that justice is done. In other words, there's a need to put a full and fair picture before the court. And our application is also partly based on the principles that were enunciated in R versus Hepworth. We've given this citation on Friday, 1928, AD 265 at 277, wherein the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other, and that the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. In paragraph 1.9, we submit in the alternative, my lord, that section 167 of the Criminal Procedure Act 51 of 1977 also deals with the current application that the state is bringing, and it says that the court may at any stage of the criminal proceedings examine any person other than the accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and the next portion we bold, my lord, and may recall and re-examine any person, including an accused, already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if his evidence appears to the court essential to the just decision of the case. We also refer to section Section 186, actually, my lord, not 86, Section 186 of the Criminal Procedure Act, which provided the court may subpoena a witness if the evidence of such witness appears to be essential for the just decision of the case. And should we not be successful on the general principles, my lord, we request that the court should exercise the powers conferred on it in terms of Section 167, as we have alluded to. Now, in paragraph 1.11, my lord, we set out the reasons as to why it is essential to re-examine Brigadier Gininda on these photos. We've already dealt with paragraph 1.11 on Friday, my lord, up to page 6, my lord. We quoted the contents of these pages verbatim on Friday. We are not going to rehash that. We are going to deal with the reasons why evidence was not led in examination in chief of these witnesses. This is on page 6. Paragraph 2.1. As we alluded to earlier on, the investigating officer requested at the time that only certain photos found on the downloads of accused number 3 should be included in Exhibit S, the affidavit of Sergeant Mabasa. And as we've already intimated, these photos are also included in the affidavit of Lieutenant Colonel Stein at the request of the investigating officer, Brigadier Gininda. And the purpose at the time was to identify the clothing and the dreadlocks of accused number 3. So the focus, my lord, was mainly on the clothing and the dreadlocks. Now, evidence has now been presented before the court, and there has been cross-examination. The state intends to present the additional photo of accused number 3 in its 3 forms to show other features of accused number 3 that were canvassed during cross-examination by Advocate Nisi, such as the gold tooth. Paragraph 2.2. Insofar as accused number 2 is concerned, the state seeks to show more photos as further appearance of accused number 2 as came up in the cross-examination of Brigadier Gininda, as an issue was joined with him regarding the identification of accused number 2 by the witnesses. And the same argument obtains for number 1, my lord, that the state wants to show his general appearance as testified to by the witnesses, and in particular Brigadier Gininda. Paragraph 2.3, we deal with the reason why the evidence was not presented during evidence in chief. We mentioned, my lord, that it was only during the long adjournment that was afforded to Advocate Nisi to prepare his cross-examination, that the state was able to go through the over 5,467 photos of the downloads of accused number 2. And we make the point, my lord, that these downloads were given to the defense a while ago already, and that the state has extracted a photo from the cell phone downloads of accused number 3, which if the application is successful, will be presented in 3 different forms. And 16 additional photos were also extracted from accused number 2's downloads, including actually 2 photos of accused number 1 that we want to show to the court. We mentioned, my lord, that accused number 2 and 3 do not dispute the cell phone or stroke SD card from which the downloads were made belong to them. We mentioned that in light of the fact that the photos belong to them, including the 2 photos of accused number 2, that they therefore fall within their personal knowledge. We therefore, my lord, submit that there will be no prejudice to them. In paragraph 2.4, we mentioned that the evidence will be of short duration, as the downloaders are simply going to confirm that the downloads were burnt on the CD and authenticate, and they will just authenticate those photos. And on page 7, my lord, we deal with the interests of justice. We have already placed our argument on this point on Friday, my lord. We're not going to repeat that. Safe to mention that in paragraph 3.1 that it is respectfully submitted that it is in the interest of justice to allow this evidence, as it will assist the court to adjudicate on the issues that are in dispute, and that the evidence is therefore relevant. We again quote the case of R versus Hepworth, the case of State versus Sheikh and others. Paragraph 3.4, the multi-choice limited and others versus the National Prosecuting Authority and another. And on page 8, paragraph 3.5, we also repeat the authority that we quoted on Friday. And in conclusion, my lord, and I see there's a typing error there. We respectfully submit that the state be allowed to recall these 2 witnesses. I'll try to establish the attitude of my colleagues to this application this morning, but they were still going to have a discussion. I'm here to be apprised of what standpoint they will adopt regarding the application. As a court, please.
You want me to adjourn?
As the court pleases, my lord, that was going to be my suggestion, in the light that I also stand in for Mr. Mngube and Mr. Sibia, so that I can take proper instructions, my lord. As the court pleases.
When should I come back?
I'd suggest, my colleagues, sorry.
It's 4 minutes to 11. Maybe we can take the short adjournment and come back at 11:30 if it's fine.
That will be suitable, my lord. As the court pleases.
Is that okay? 11:30.
As the court pleases, my lord.
Interpret for them first.
khona-ke udaba-ke bafowethu la kade silidingida-ke esontweni elidlule-ke malana phecelezi ney'thombe lezi ade befisa ukuthi bezijobeleleke kufakazi obukhona-ke bey'thombe buhambisana nemibukiso ka-exhibit S-ke lapho-ke phecelezi ezithombe lezi ziquka khona-ke umnumzana uSibiya-ke uqala-ke futhi umnumzana uNtanzi futhi nomnumzana wesithathu-ke lapho-ke la bakhuluma khona-ke ngey'thombe bangathanda ukuthi babize futhi abofakazi ababili-ke lapho-ke warrant officer Mabasa futhi noSergeant Mabhena warrant officer Ndlovu futhi noSergeant Mabhena kuthizini baze futhi phambi kwinkosi enkantolo-ke bethi ufakazi babo malana ney'thombe lezi phecelezi la khona-ke kukhulunywa ngey'thombe ezimbili-ke zakamsola oqala-ke futhi lapho-ke futhi ney'thombe ezintathu futhi ney'thombe lapho eziyishumi elinesithupha-ke zakamsola wesithathu-ke lapho-ke futhi ney'thombe ezinye ezikhona-ke lapho-ke zakamsola wesibili la bangathanda ukuthi bakhulume phecelezi ngazo-ke la baze bakhuluma khona-ke ngey'thombe zakamsola wesithathu ukuthi khona la bangathanda ukuthi bakhulume ngazo-ke kepha-ke iy'thombe lezi eziqhamuke ngendlela ezintathu ezahlukile-ke lapho-ke la sitshengisa yena khona-ke anama-threats la kuyena ke ekhanda futhi wathi ithumbu lezi bazithubula ngaphakathi ocingweni lwenu ke banumzana futhi ezinye ithumbu lezi bazithubula ngaphakathi kwe-SD card shuthi i-memory card ke lapho ke manje bathi bakhulumile ngazo mayelana nodaba lolu le-XRY system lapho ke kade bedownloada khona ke warrant officer amabasa futhi bakhuluma ngazo ke futhi bese wasifaka ngaphakathi kwe-CD noma i-disk ke lapho ke ngemuva kwalokho ke biswafaka ngaphakathi kwesikhwama leso isikhwama sivalekile bathi exhibit bag ke lapho ke lezi bangathanda ukuthi ke bakhulume ngazo manje ithimba labameli benu ke lapho ke liyacela ukuthi inkosenkantolo ithi ukuhamba kancane ithathe ithole isikhashana esincane ke la bazokhona bakhulumisane ngethombe lezi ke bese bakhulumisane nani ke lapho ke futhi washo khona njalo ukuthi umnumzana uRamusipili naye ke futhi lapho ke uyena ke ongene icathulweni zakababa umnisi ke ngoba yena ngekho laphambi kukesenkantolo futhi angathanda ukuthi ke akhulumisane nabanumzana laba abamele ubaba umnisi phecelezi ngodaba lwezi lolu lweyithombeke.
Thanks. 11:30 then. This is the application.
As the court pleases, my lord. My lord, with respect to Mr. Sibia and Mr. Mngube, they have requested me to implore the court to allow them the opportunity for Mr. Advocate Munisi to respond to the application, because there's a further instruction emanating from Mr. Mngube which pertains to this particular photo, the 3 photos that the state intends to use, and he says he can only give that instruction to Advocate Munisi so that he can relay it to the court as well, my lord. So they've implored me that we ask for an adjournment so that they can then instruct Advocate Munisi to respond substantially to the application, and as well as myself, my lord, I'm going to request an opportunity as well to draft short heads of argument to respond to the application by the state, my lord.
Yes, Mr. Mumalo.
My lord, I was informed by my colleague, Mr. Ramsepeda, about his submissions. I was also thinking that maybe we can assist the legal representative for accused 1, 2, and 3, because to me, my lord, these are not matters that falls within the terrain of my client.
Yeah, so what are you saying? Are you opposing the application?
I think it would be better, my lord, that accused number 3, Mr. Mngube, be afforded that opportunity to further instruct his legal representative, Mr. Nisi, about any further issues that he wants to raise.
Yes, Mr. Orolo.
Thank you, my lord. I think I also need contributions from Advocate Mnisi, my lord, regarding my response to this. Thank you, my lord.
Yes, Mr. Balui or Mr. Sebani.
As the court pleases, we don't object to the request, my lord.
Further, during the short break, I requested, because during his submissions, Advocate Baloi mentioned that there were over 5,000 photographs downloaded from the memory card of Mr. Ntanzi. So during the break, I've requested same to be availed to me, and indeed, Advocate Sibanda has sent them through to me via WhatsApp and via email, my lord. So I need to consider.
How many are those photos? I thought you were talking about 16 and 3 and so forth.
Is the ones that we want to use as far as accused number 2 is concerned as 16, and accused
16.
number 1, yes, it's only 2.
So it's 18 photos.
Yes, indeed, my lord, plus the one of accused number 3, so it's about 19 photos.
19 photos. So you want those photos?
No, those ones have been availed, my lord, because my instruction from the accused, he wants to see the further photographs that they say were downloaded from his memory card. But
The 5,000.
It's not actually 5,000, my lord. We've gone
What?
through some of the data here is deleted, so I'll actually look at the number of photos, but I don't think they come as close as 5,000.
How many are those photos, Mr. Balui?
We can give the number of files, my lord, but it's difficult to tell the number of photos. As my colleague has pointed out, some of the files have been deleted. So one will have to go through them individually.
But just, my lord, to be firm on this one, the ones that the state intends to use in their evidence, those have been availed to me, the 19 photos, my lord.
So we should adjourn until when? Next year?
Until tomorrow, my lord. I'll communicate with Advocate Munisi. I believe he'll be here tomorrow. As the court pleases, my lord.
Okay.
manje kade becela ke abameli ke ukuthi ke lapho ke mara nodaba okuthizeni baphendule ke udaba lwezithombe ke lezi ezi19 bathi bafisa ukuthi umnumzana omnisi ke naye bekhona ke ngoba ke umnumzana noba abanomzana bamelo uyena ke lapha ngaphambi kwenkantolo ke bathi kunodaba ngathana ukuthi bandlulise ke noma bakhulumisana naye mathupha ke bephecelezi nodaba lolu lwezithombe ke manje becela ukuthi udaba lolu lwezithombe sihlehlise noma icala elibahlehlise kuze kufike ilanga la kusasa ke la azoba khona la ngaphambi kwenkantolo ke umnumzana omnisi kuthizeni sesikhuluma ke ngodaba lolu lwezithombe ke
Tomorrow.
Phakameni bafowethu. Sorry.